Welcome to the All Rise podcast, Sunday Scaries. I'm your host, Christine, a civil litigator and personal mentor. Every Sunday, we'll tackle those dreaded Sunday Scaries together to demystify the practice of law and provide you with actionable tips and guidance to face your week ahead. So grab a cup of coffee, take a deep breath, and join me while we turn those Sunday Scaries into stepping stones towards your success. Let's get started.
Welcome back to the All Rise podcast, Sunday Scaries. I'm your host, Christine Barker, and today is our final segment in our four-part series on case handling from start to finish. Today we're talking about trial and trial prep. As the associate, your role in preparing trials is actually really important. Like with mediations that we talked about last week, there are ways that you can become indispensable to your partner and so that you can focus on getting a case prepared for trial. As the associate, you're going to kind of be working in the background, but that's very, very important. In fact, it's probably the most important thing is organizing everything in order for your partner to be prepared to do things like direct examination, cross-examination, voir dire, jury instructions. In fact, I was just preparing for trial last week, and I cannot tell you how indispensable my associate was in just helping me get exhibits together and things like that. So your partner is going to be focusing on the strategy, how we're going to be presenting the evidence to a judge or to the jury. I'm going to be managing client expectations, making sure that, it's never a slam dunk. Any given Sunday, a judge is going to go one direction or another. So I need to let my clients know that, what the chances are that we're going to be successful at trial. And then obviously presenting the evidence. How am I going to present the evidence in a understandable and cohesive manner to a judge or to a jury? So what I need from my associates is somebody who's going to handle things like legal research, organizing the exhibits, preparing witness outlines, going through old deposition transcripts, letting me know what's important, what they testified to, so that I can be prepared for rebuttal if I've got a witness on the stand who testifies differently than what they did in their deposition. So your goal as the associate is to kind of be the backbone of the trial team. You're going to be providing to help so that we can provide a seamless presentation of the evidence. The first thing that you're going to want to do as an associate to get a case prepared for trial is to run a trial calendar. Most firms have, some sort of software that does their calendaring. My firm uses CompuLaw, but there's a bunch of them out there. But what you'll want to do is run a trial calendar. This is going to give you all of the deadlines, all of the dates, so that you are prepared for when trial comes up. So you know when discovery cuts off, motions cut off, expert witness depositions cut off, when you have to file your motions in limine, when you have to do an issues conference, when you need to exchange documents, and what's going to happen on first day of trial. Courts are different. So for example, LA County Superior Court, where I do a lot of my practice, they do an issues conference before, like your final status conference is going to be where you're going to argue motions in limine and you're going to exchange those pretrial documents. But because you're arguing motions at the final status conference, you need to serve those motions prior to that, and that has to be done by a statutory timeline. Orange County is different. Orange County wants you to bring all of your documents, including your motion in limine, to the first day of trial. That's when we're going to set with the judge a scheduling order with respect to when motions in limine are going to be heard, when oppositions need to be filed, if reply briefs are going to be filed. So you need to know your jurisdiction. As an associate, it's really important. So you're going to run that trial calendar through whatever calendaring system your firm has, but you're also going to pull the local rules. So LA County Superior Court, Orange County Superior Court, San Diego, San Bernardino, they all have different local rules. So you want to pull the local rules for the jurisdiction that you're in. Here's a little tip for you new associates. The local rules. These are the rules that are specific to that judge's department. Every judge is different. They like things done differently. So to kind of rise and shine and sparkle with your partner, pull the local rules for the particular judge, and make sure that the judge that you were assigned to in the beginning of the case is still your judge. Sometimes cases get juggled around, they get moved to different departments. Also, LA has a master calendar or a direct calendar. Make sure that you're pulling the local rules for the judge who's actually going to be your trial judge, not somebody like a master calendar where that's where the case is going to be heard throughout the course of it until it gets to trial. And then it's going to go out on the wheel. That's what we call it in LA. It goes out on the wheel and then it gets assigned to a direct department. So make sure that you understand your jurisdiction. And if you are on a direct calendar or if you're on a master calendar, and making sure that you're pulling the local rules for the judge who's actually going to be your trial judge. Okay, now 2 types of trials, bench trial versus a jury trial. And understanding the differences between the two and then why you might want one or the other. So a bench trial obviously is conducted from the bench. This is where the judge is the fact finder and there's no jury there. So you're going to be presenting your evidence just to a judge. This is typically faster. It's a little less formal, but it's still formal. I mean, you're still going to have to abide by the rules of evidence, but it's not as formal as if you had a jury there. It's also usually a little bit quicker because you don't have to, again, worry about voir dire, jury instructions, and making sure that the juries, are taking the breaks that they need to take. Some judges will go, if it's a bench trial, just get on the bench and just get going. It's also a little bit easier too when you're doing a bench trial because you can stipulate to a lot of things. If there's a contract, the court probably doesn't want you to go through foundational things about establishing, did you sign this contract? Did you sign this contract? Is this a true and accurate copy of the contract? They'll allow the litigants to stipulate to certain facts. It makes the process run a little bit faster. The bench trial is ideal if you've got a complex legal issue that is going to be a little too difficult to explain to a jury. So if it's something that's more fact-driven that can't be decided on, say, a dispositive motion, but it's too complicated for really a jury to understand, you may want to go with a bench trial. You'll decide this early on in the case. Usually courts want to know this during the case management conference time frame. And you also usually have to push jury fees early on in a case if you actually do want to impanel a jury for your trial. Jury trials, obviously, these are, a jury of your client's peers, not your peers, your client's peers. And these are definitely more formal. This is where, you're going to have to do voir dire. You'll probably have some sort of jury questionnaire that you're going to present to them. And then when evidence is presented, you're presenting it to the jury for them to understand so that they then can make a ruling and a determination at the end of the trial. This is more suitable, I feel like, especially coming from the defense side, for where there's an emotional attachment to the case, where it's not a cut and dry kind of factual issue or a cut and dry legal issue. It's more squishy, where the facts are a little more tangible and emotions might be a little more high. So that's where you're going to kind of want a jury. Most plaintiffs and plaintiffs' attorneys are going to want a jury trial. Because they want to personalize things with the jury and help them to identify with the plaintiffs. Nothing wrong with that. There are times as a defense, I want a jury because I need them to identify with my client. If my client perhaps maybe didn't follow the letter of the law to the T, but there's reasonable reasons why they didn't, maybe I want a jury who's going to be able to identify with my client. And look, they were just kind of employing common sense. And that's why they didn't follow kind of the letter of the contract or the letter of the law. So this is something that you'll want to sit down, obviously, with your partner and strategize as to which venue do you want it in. Do you want it as a bench trial or do you want it as a jury trial? Whether it's a bench trial or it's a jury trial, you're going to have an issues conference. And these are usually done a couple of weeks before the trial date. Most courts are going to want the attorneys to get together and sit down. You can do this in person. You can do it over Zoom. You can do it as a phone call. Some jurisdictions do the issues conference actually as a hearing where you have to go into the court, you bring all of your documents there, and then you sit down and it's really kind of housekeeping. But issues conferences are really, really important, and they do help streamline trials. So for example, this is where you're going to talk about witnesses. Who do you plan to call? How long do you think they're going to be on direct examination? How long will they be on cross-examination? What exhibits are you going to be introducing at trial? It's funny, as before I became an attorney, before I even went to law school, I'd watched the legal dramas and stuff. Perry Mason was one of my favorites. It's still one of my favorites. But it always seems like there was like surprise evidence coming out, like, oh, surprise witnesses. It's not really the case, in real life. Like, you exchange all of this information beforehand. So you're going to exchange witnesses, you're going to exchange exhibits. You're going to say, here are the exhibits that I plan to introduce at the time of trial. Courts will want you to try and stipulate to things like authenticity, all those foundational things, so that it kind of speeds the trial along. Obviously more so in a bench trial, but they also want to do that in a jury trial as well, because it's a jury of your client's peers. So they might not necessarily understand what you're doing when you're trying to authenticate a document. And they might get bogged down with that when really they need to be paying attention to, what the parties did with that particular document. So judges will like the parties to stipulate to things like judges will like you to stipulate to foundational things. Also during the issues conference, you're going to talk about motions in limine. These are pretrial motions that get filed with the court, and you're trying again to streamline the issues. You're asking for the court or the judge to rule on a specific legal issue, and it helps to narrow down the things that are going to be presented during trial, either to the judge or to the jury. Motions in limine are usually going to be things that you're going to try and exclude evidence. So things like exclude lay witness expert testimony. So if you've got a witness that you think is going to try and testify as an expert and they have not been designated as a retained or non-retained expert, you might want to bring a motion in limine beforehand that says, this is a lay witness. They are not allowed to testify as an expert. Their opinions only can be that of a third-party observer. They are not expert opinion testimony because they have not been qualified as an expert. Another kind of common motion in limine would be a motion to bifurcate damages. This is particularly important with punitive damages because you want first a ruling on whether the actions of a defendant rose to that of punitive nature, and then separately decide what the damages are with respect to those actions. Motions for summary judgment or motions for summary adjudication, these are dispositive motions. They are usually filed well before trial. I know here in California, I think it's 105 days before trial because it takes into account the 30 days of prior to trial where motions and discovery cuts off. But again, sometimes this can be a really good tool to narrow the issues if it can't dispose of the litigation completely. And again, this might be something that you'll want to sit down and talk to your partner early on during the litigation so that you can kind of strategize whether you want to bring a dispositive motion or not, what issues you'd like to bring that dispositive motion on, and if you can either dispose of the case or if you can at least narrow the issues. It's a really, really helpful tool, but you need to be thinking about that well in advance because the timelines and the deadlines are very strict and they're far enough in advance that it's not something that 30 days out before trial, you're like, oh, maybe we should have brought a dispositive motion. It's a little too late at that point. There's things that you can do, asking the court to continue the trial or asking the court to shorten time. But if it does look like something that you can narrow issues or dispose of a case with a dispositive motion, you're going to want to do that sooner rather than later. So we talked a little bit about the pre-trial things like witness lists and exhibit lists. Exhibits are key during trial, and as the associate, you can make yourself indispensable to your partner by really knowing the exhibits inside and out and having them organized in a way that is readily available to be able to jump to and find a document that you need. All of the exhibits should be tabbed and indexed. So I like to do these. I'm old school. I like a 3-ring binder. I do know that the courts now like them to be lodged electronically, but some courts still do want you to drop off actual trial binders to the courtroom itself. Most of the judges are old school as well. So I like to have a 3-ring binder with all of the exhibits that I potentially could use during the trial. An index in the front of the binder letting me know which exhibits are in the binder, and then everything tabbed on the side. I like to have a separate binder as well that doesn't have my notes, because I use my trial binder. I'm making notes in there, things that are going to help me jog my memory, because again, as the partner, I'm trying the case. So I am questioning witnesses, I'm working on strategy. And so I might use some shorthand or something like that while I'm making notes in the margins, but I need a clean copy so that if during trial the court is like, do you have an extra copy? I'm able to pull one out. Or as my second chair, as the associate, you're able to pull that out and present that to the judge. So we talked a little about exhibits and then also witnesses. So again, as the associate, it's going to fall upon you to help prepare witnesses for their testimony. This is going to be things like reviewing deposition transcripts. When I was an associate, I had partners always ask me to do page line summaries of depo transcripts. I don't ask for those. There might be some partners out there who still like them. I really don't. I never really found them that helpful. What I did find helpful was if my associate would review a deposition transcript, highlight the important sections, and then tab those things. And what I would do then is I would go back, review the transcript, and I could look at the tabs where they're like, hey, this fits with this issue, or if you are trying to advance this fact, here is the section. And then I can read a little bit below, a little bit above, a little bit below, and kind of gauge the context of what that testimony was. For some reason, page line summaries just didn't work for me. But again, it's partner by partner. So ask your partner while you're preparing for trial, do they want page line summaries? Number one, they're going to be appreciative of the fact that you're thinking ahead. And then number two, they're going to like your lingo, the fact that you know what a page line summary is. And what a page line summary is, it's basically you would read a page of the deposition and then you would create a chart where this is the page, this is the line, this is what they said. Again, I never really found it that helpful, but some people do. So ask your partner, do you want page line summaries or not? Otherwise, I like just for it to be highlighted. I like it to be tabbed. I also am really into color coding. So when I tab my deposition transcripts, I will tab using different colored Post-its for different issues. So then I know I can flip to that page. And here we're talking about, terms of a contract. Here we're talking about damages. So just, again, everybody's different, but it's one way of organizing. And the important part here is to sit down with your partner and find out how they like it organized. And then you as the associate will go and take care of that. Also with preparing witnesses, it's really helpful to have an outline of what you're going to be questioning the witness on the stand. So if I've got 6 different witnesses, I need to know that these are the things that this witness can testify to. They're going to be able to testify to formation of the contract, and they're going to be able to testify to communications. Then this witness might be able to testify to damages. This witness over here might be able to testify to, discrepancies in the plans. So it's really important as the associate to prepare those outlines so that your partner knows which witness is going to be able to testify to which things. Mock testimony is also really important and could be a really good tool. I don't always do it, but sometimes I do. Like when I sit down and prepare a witness for trial, and I'm like, look, this is what you can expect at the time of trial when you're on the stand. And I do tell my clients all the time, I've actually never been deposed. I've never given testimony in a trial. I've taken lots of testimony. I've done plenty of trials, but I've actually never been in the hot seat. So I like to let my clients know that so that they understand that, look, I understand it's uncomfortable. It's not the most pleasant thing to do. Depositions, trial testimony, it's not like a normal conversation where it's, you're kind of having a conversation between two people. Sometimes you finish each other's sentences. Sometimes you interrupt one another. During deposition, and then more importantly at trial, it's question, answer, question, answer. So it might be a good idea to set up an opportunity for your client or your witnesses to do a little mock testimony so that they know what to expect. Sometimes I'll even play devil's advocate and I will be the opposing counsel. And I'm like, look, this is what you can expect on cross-examination. These are the kinds of questions that they're going to ask you. And I now know enough about my opposing counsel. I probably even know their tone. So I can tell my client, look, this is how this person's actually going to question you. If they're real aggressive, if they're a little more demure, if, just kind of how, so, and then give them that real life experience. And I'll do, 20, 30 minutes of it just so that they can get a feel of it. So the first time that they're cross-examined isn't on the stand. They've actually had an opportunity to do it with me. And as the associate, that's something that you can help set up. If your case is a jury trial, then obviously you're going to have to do jury selection. Again, this varies to jurisdiction, but for example, Orange County jurisdiction, this is where I was just preparing for trial this last week. They like to have a voir dire questionnaire. So I submit that to the court. I submit that actually during the issues conference with my opposing counsel. First, we discuss the questions that I want to present to the jury. We try as best we can to agree upon the questions that are going to be submitted to the jury. We give that to the judge. The judge then gives that to potential jurors. And that's kind of our first level of voir dire, trying to figure out which potential jurors are going to be suitable for our trial. Then there could be an oral voir dire where you've got actual jurors in the jury box and you're asking them questions. So jury selection, very, very important. And it depends on the case, on what kind of what kind of juror you want to actually pool. So you want to do research on your jurisdiction. What types of people are in this jurisdiction? What's the likely jury pool that you're going to get? You want to know this beforehand. Really important is jury verdicts that have come out of this exact jurisdiction with fact patterns that are similar to your case. Most clients, especially insurance clients, are going to want a pre-trial report from you, usually about 60 to 90 days before the trial, and they're going to ask you for jury verdicts. So it's a really good tool to kind of go pull those different verdicts. I know that Westlaw has it, Lexis has it, some other, I'm sure that there are others out there. But you can insert the facts of your case and you can start pulling what have other juries done with similar fact patterns. That gives you a lot of information beforehand, and then it helps your partner to decide how they're going to present the evidence. It's also going to help your client to determine whether they should try and settle this case again or if this is something that's worth taking to trial. A well-selected jury can significantly impact the outcome of a trial. So jury selection is really, really critical. And as the associate, it's something that you can be helpful in by doing the things of outlining jury questionnaires, jury verdicts, and assisting with the voir dire, as well as jury instructions. Those instructions are going to be discussed during the issue conference, presented to the judge, and then those will be the things that get sent back with the jury when they do go into deliberations. And remember, those jury instructions are the same instructions that we pulled at the very, very beginning of this case as we were creating our discovery plan and outlining our path to this trial. Next are opening statements. Opening statements kind of set the stage for the trial. Now, keep in mind, opening statements are not argument. So trial partners, trial attorneys can get a little theatrical, and maybe try and push the boundaries a little bit of opening statements, but they are not supposed to be argument. What they're supposed to be is, the evidence will show this. The evidence will show this. You're going to hear from this witness. You're going to see this exhibit. You're going to hear these facts, and it's going to show X, Y, and Z. Helping your partner kind of craft a good opening statement is crucial. And the way that you can do that as a new associate is knowing the facts. I can't stress it enough that as a new associate, you need to know a case inside and out. You need to know the client, the witnesses, the documents, any little minutia of the case. That's how you become an indispensable to a partner. Your partner is over there trying to strategize. How am I going to present the evidence that I have in the best way possible? But you need to know the evidence so that they can kind of reach out to you and be like, hey, when was that date again? When was the contract entered? Is there an attorney's fee provision? Was there an alternative dispute resolution provision? Those things, as an associate, if you know those things inside and out, your partner is constantly going to come back to you. And just like anything, my clients continue to send work to me because I give them a good work product. Your partner will continue to work with you if you continue to give them a good work product. With opening statements, I used to, as an associate, I would offer to my partner for them to try out their opening statement on me. I know the facts because I'm the associate and that's my job. And I would offer to my partners, go ahead and tell me your opening statement. They need to practice as well. They want to make sure that they're not coming off too scripted and that they're not stumbling over potential facts. You as the associate who know those facts inside and out are the perfect person for them to talk to and to practice that opening statement with. So once we've got through opening statements, now we're going to get into the evidence, and we're going to do this either by direct examination or cross-examination. Direct examinations are usually pretty scripted. These are questions that I've already spoken with my client about. We've already practiced it. So I know I'm going to be asking these questions. I know that my client is going to be answering in this manner. So helping in crafting and outlining those direct examinations are really, really crucial. Cross-examination is a little more kind of on the fly because you're listening, your partner's going to be listening to the direct examination and then deciding what they need to ask on cross-examination. Now, they've already heard a witness's testimony, likely in deposition. So if you, as the associate, have reviewed the depositions, you have them highlighted, you have them tabbed to the key deposition testimony, while listening to direct examination, you can be jotting down notes where, oh, they said something different in their deposition, or that's not exactly what they had said before. Or we can expand on this in, with further testimony. So those are really, really key things to be doing. So if you're sitting second chair with your partner, by all means, have a notepad, a pen or a pencil, and got your deposition transcript there, and you're taking down notes. Whenever you hear something in direct examination that isn't quite right, or that has been described a little bit differently, make sure that you're taking those notes down. As an associate, when I would ever second chair a trial, I used to keep a stack of Post-it notes next to me, and I would jot down notes and I would hand those to my partner. Now, they didn't always take my thoughts into consideration, but they were things that I was hearing during the direct examination and sometimes even during cross. And it was just things that I knew that I had heard and maybe they hadn't heard. And it's just really, it helps to have that team environment that we're both listening to the testimony and it's coming through different funnels. And as the associate who knows these facts inside and out, your insight could be key into how the cross-examination goes. So kind of pro tip, keep a stack of Post-it notes with you and jot down things. While you're preparing for trial, you do get to know each other very, very well. And you have to kind of build that rapport with one another so that you can't be hesitant or embarrassed or conscientious about passing a note to your partner, even if your partner disregards it. Because there's going to be that time, the 1 in 3, the 1 in 5, the 1 in 10, that you pass that note to them, they look down, they're like, oh, I do need to go back to that. So as best as you can, try not to be self-conscious about whether or not your partner takes your recommendations or not. It's just getting more information out there. And at the end of the day, the goal is to provide your client with the best legal representation possible. And you can only do that when you set your ego aside and put your client's interests first. Once you've gotten through all of the direct examination, cross-examination, all of the evidence has been presented to the jury or to the judge, whoever the fact finder is, time for closing arguments. This is where you get to argue, or where your partner gets to argue. But your role as an associate in preparing and second chairing a trial is demanding, but it is really rewarding because it's kind of cool at the end to see it all come together. To see your partner stand up there and say, during their closing arguments, we just showed you this, this witness just testified to this. We just proved to you X, Y, and Z. They're allowed to get a little more spicy because, again, it's argument, it's not opening statement. So what really does closing arguments kind of look like? Well, it's going to summarize what was just said, what was just testified to, all the documents and evidence that has been put into evidence in front of the jury. You're going to be tying together themes. So this is a really good thing at the beginning of trial where you're working on those trial themes. Now at the closing arguments, you kind of bring those themes back in and kind of tie everything back together. And then I like to end all of my closing arguments with a call to action, which is I'm asking the jury to do this. So as an associate, again, this is a really good time for you to kind of help your partner bounce ideas off of them. Be the sounding board that they need, because again, they're trying to strategize and to pull all of this evidence and all of this information together, present it in the most cohesive way to a jury, and then kind of close everything up, put a nice little bow on it. So you as the associate being that sounding board and providing your partner with that feedback is invaluable. So thank you so much for tuning in to our 4-part series on case handling from start to finish. I hope this was really helpful for you. Please continue to stay tuned to the All Rise podcast, our Sunday Scaries. If there are topics that you would like for us to cover, please let us know. Shoot us an email, drop us something on social media. We would love to hear from you. And in the meantime, thanks so much, and we will see you soon. Keep rising.